Talk Law Radio. That's what he was supposed to tell you, that I'm the host of a radio show. It's on KLUP 9:30 a.m. The Answer, Saturday mornings at 11 o'clock in the morning. Okay, so first, I kind of want to know what y'all are interested in so that I can talk about that. Of course, I can talk about a lot of things that you might not be interested in. But if somebody really wants to know some specific thing, raise your hand and, yeah.
Trusts.
Okay. Same thing for you. Anybody else? Okay, well, one question that I get a lot is about, tell me the difference between a will and a trust. And so I'll start my presentation with this question. What three things have to happen in order for your will to be useful? You have to die. Anything else? Something of value, probate. And number one, you have to have one. So if you don't have a will, the state of Texas has statutes that say who gets your stuff. You write a will so that you can specify and have a legally enforceable document that says who's going to get your stuff, when they're going to get it, how they're going to get it. You can decide all of those things with the will. But the point I was trying to make was the probate point. Some people think by having the will, it's already useful, but there's a specific statute in the Texas Estates Code that says a will is not enforceable until it's probated. And the word probate comes from the Latin word probare, which means to prove. And so part of the reason for probate is proving that you have a valid will. Now, if you go to an attorney like me, you'll get a valid will. But there's a lot of people out there that don't have a valid will because they wrote something on a napkin. Have you ever heard of Howard Hughes, the movie producer and airline test pilot? Well, he wrote lots of wills on napkins, on scraps of paper, and so when he passed away, his estate was in probate court for 20 years because each one of those documents had to go before the judge and they had to evaluate, is this one the last will? They call it the last will because it's the last one that you did before you passed away. Well, there was people that said they were married to him. There was people that said they were his kids. And so the judge ultimately decided, probably through a settlement, that his foundation in Florida would get some of the money, and then a whole bunch of heirs got some of the money too. Have you ever heard the term laughing heir? No?
What was it?
Laughing heir. This must be something that's just funny to lawyers, I guess. Well, a laughing heir is somebody who inherits property or assets from you, but because they didn't know you, they're not sad. So that's why they call them a laughing heir. Somebody that inherits from you that didn't know you is said to be laughing. Okay, back to will versus trust. So we've already decided that the will is a death instrument. It takes effect upon death. A trust, on the other hand, is a living instrument if you create it during your life. Now, there are some trusts that spring to life after death, but we'll talk about the one that is living, that you create during your lifetime. Another difference is that we put a special section in the trust document that says what happens if you're incapacitated, if you develop Alzheimer's or dementia, that type of incapacity, if you're not able to pay your bills or collect your income or manage any of your stuff. So in that section, we can say, How is it decided that you're incapacitated? Have you ever known anybody that admitted that they were incapacitated? I meet some of them sometimes. They say, Todd, I'm going crazy. But they really mean it. They're losing their memory is usually what they mean. Other times, I'll meet with an adult child or other family member that says, Dad's going crazy. He's losing his memory. He's not paying his bills. He won't go to the doctor. He doesn't remember to take his medication. So only a court can judicially declare you to be incapacitated. But you don't always have to rely on the court. You can agree in advance through the words in your trust that you'll be deemed to be incapacitated and allow a successor to manage your affairs upon either someone deciding that you meet the definition of incapacitated. So you could leave it up to your successor trustee that says, well, based on his behavior, we think that he's substantially unable to make his own medical and healthcare decisions and substantially unable to make his own financial decisions because of a medical condition, a disease, or injury. Or you can have a panel, and you can vote. I like it. I'd like to have a vote. If everybody else says I'm incapacitated, then maybe I'll go along with it. Or you can require a doctor. Say, if my physician says I'm incapacitated, then I'll go along with it. But what's a problem with relying on the physician?
They don't know as much as a son or daughter are going to know.
They might not know.
It's not
Yeah.
heart to heart with them, just another person.
Well, the problem I'm thinking about is when the person refuses to go to the doctor because they might find me incapacitated. So I put a special clause in there that says, if you refuse to go to the doctor, you're going to be deemed to be incapacitated. But this is something you have to agree up front when you're healthy. So we call that the disability panel. And like I said, you can put whoever you want on there. The other thing I like about the incapacity section in a trust is that you can specify how you want to be taken care of. Some people don't know. I think that you should start thinking about it even though you're still healthy. For me, I want to be in like the memory care resort. There's a couple of them here in town that are pretty cool where it's like kindergarten and you have stations where you can go experience different things. I think if I had no memory, I would like that. But it costs about $8,000 a month. So you need long-term care insurance for that, or you need to save a bunch of money. Danny can help you with that. So I call this the take care of clause, how you want to be taken care of. Some people hate the idea of spending $8,000 a month, and they want to leave the largest inheritance possible to their beneficiaries. And so if you're in that view, well, we want to write that down so that they don't make an error and start spending your money on things you don't want. The middle ground is those people that just want assisted living or memory care based on whatever the doctor says. But try and balance the cost of this long-term care with how much is there so that something's left. I've recently been meeting with a lot of people that just want to leave something. Because I always ask, what is it that you hope your beneficiaries will achieve by receiving an inheritance? And maybe 1 in 10 have a big goal, like reduce poverty, or save the children, or grow the church. Other people just say they can do whatever they want with it. Maybe 1 in 10 have a beneficiary with a problem, like they're in jail, or they gamble, or they do illicit drugs. Well, we can plan for that too. Some people just want to balance everything out. So the trust is good because it has the take care of clause, the disability panel, and it's something that you can do to make things easier before you pass away. So I ask people, do you want to make things easy for you now, or do you want to make things easy for them later, your beneficiaries and the people that are going to be wrapping up your affairs? Because in order to make the trust work, you have to do certain things. You have to put your assets in the trust. So if you don't have one already, think of a bucket. The trust is kind of like a bucket. And when you buy a bucket from the department store, the Home Depot store, it's empty. You put your stuff in it, whatever you want. Well, the trust is kind of like that too, because the trustee holds the bucket, and the trustee can carry out the terms of the trust as to the assets that are in the bucket. And so if you leave something out of the bucket, then it's an asset of your estate that's subject to your will. And if your whole goal is to avoid probate, we want to make sure everything is in the bucket. And so those are the big differences between will and a trust. Hope you appreciate that. And you can put a whole lot more terms in either your will or your trust about how you want people to use the assets or not use them. Some of my clients call that ruling from the grave. They say, I don't want to rule from the grave, or they do. Some other things that we do to help people plan: if you have a business, we kind of coordinate your business with your estate. And if you don't qualify for long-term care insurance because something's wrong with your health, or if you just haven't saved enough and you're worried about what's it going to be like to be on government benefits like Medicaid, we can help with that too. So I focus mostly on business law and the elder law. My partner attorney, Daniel Palmer, he focuses on estate planning for the middle class. And then we have 3 other attorneys. They focus mostly on probate and guardianship of incapacitated persons. And so if you know somebody that doesn't think that they got a fair shake in the will, we can help with that too. We try and prevent that. My mission is to help people tax efficiently protect and preserve assets, reduce family conflict, and maximize benefits. So by having something in writing, you're already reducing conflict, because these are legally enforceable documents. So that's the end of my talk. Before I leave the stage, I'm going to introduce Danny.